In this video, I'll discuss a Supreme Court case that deals with the Fourth Amendment and the GPS devices. And what does the police need in order to install a GPS device on your car? The case is United States versus Jones, and the opinion is written by Justice Scalia. Here's the facts. Mr. Jones comes under suspicion of trafficking narcotics. So the police get a warrant to install a GPS device on his car. Really, the car is registered to Mr. Jones's wife, but the police think that Mr. Jones is really the one using the car. So they get the warrant. The warrant tells them that they can install a GPS device within the next 10 days in the District of Columbia. What does the police do? They wait until the 11th day to install the device. And then the car is not even in the District of Columbia anymore. It was in Maryland.
It looks like that was quite a project.
Yeah, it was. Have a look. No trade secrets here.
Thanks.
So really, they did not execute the warrant the way it was written. Mr. Jones argues that the evidence obtained through the use of the GPS device should be suppressed, because after all, the police did not execute the warrant correctly. So it was really an illegal search. And by the way, the evidence we're talking about is the data that ties Mr. Jones to a particular stash house that had large amounts of narcotics and cash inside the house. The government goes back to the basics. They say that under the Fourth Amendment, they can get a warrant in order to make a search a reasonable one. But in this situation, they say that GPS device is not even a search because it was installed on the outside of the vehicle. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Under the common law, back in the day, we always used the trespass laws to evaluate the Fourth Amendment, meaning that the landowner could exclude others, including the police, from their land. Now, in 1967, we developed a new test for the Fourth Amendment. In the case law Katz, we said that people have reasonable expectation of privacy, and that became the new test for the Fourth Amendment. Now, I already have a video on Katz, and I encourage you to watch it. The government argues that people do not have a reasonable expectation of privacy to the exterior of their vehicles, because after all, anyone, including the police, can inspect a vehicle from the outside if it's parked on a public street. But in this situation, the police did more than just inspect the vehicle. They installed a physical device on the exterior of the car and really underneath it. So in this situation, there's really a question if we have reasonable expectation of privacy. But Justice Scalia reminds us that reasonable expectation of privacy test did not substitute the common law trespass rules. Really, it added to the trespass notion under the Fourth Amendment.
Katz did not repudiate the understanding that the Fourth Amendment embodies a particular concern for government trespass upon the areas that it enumerates. The reasonable expectation of privacy test has been added to, not substituted for, the common law trespassory test.
So in this situation, because they trespassed by installing a device on the vehicle, they violated Mr. Jones' Fourth Amendment right. So the evidence obtained should have been suppressed at the district court level. So after all, the police do need to have a valid warrant in order to install a GPS device on your car. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.